Hey, what's up? It's Jules. Welcome to my channel. In this video we're going to go over the tort of negligence, specifically the duty of care element. The next heading we're going to look at is whether the law will impose that you owe a duty of care to someone for an omission. So just to be clear, when you do a negligent act, it's a little bit easier to hold you accountable because you've actually physically done something that will make you accountable to owe a duty of care to someone else. But when you have omitted to do something, it's a little bit more difficult for the law to impose a duty of care onto you, especially when you didn't do something in the first place. So what I mean by that is, let's say you're walking past a pond and it's quite a deep pond and there's a little kid drowning. You didn't create the pond, you didn't put the kid in there, you're just walking past innocently. So in law, you actually don't owe a duty of care to reach down and pick that child up in most common law jurisdictions. And that's because that is an act of pure nonfeasance, or basically you didn't do anything for the situation, so the law is not going to impede on your personal autonomy and force you to act when you didn't actually do anything in the first place. However, as in law there always is, there are exceptions to this rule. So you can owe a duty of care for an omission where you did nothing in the first place if you own the land where the thing has been created. So let's say that's your pond, so you did create that issue, so maybe you might owe a duty of care to that child if you had something on your property that you didn't get rid of. You can also owe a duty of care for an omission if you have a bit of control over the thing that caused the omission. So let's say you have a car and your car accidentally rolls down the hill, not to your fault at all. Still, it could be argued that you control that car and therefore it causing an issue even without you acting. It could be that your omission to maybe pull up the handbrake or something makes you owe a duty of care to someone else. If you'd like to see more about the duty of care for omissions, please look at my blog post below. It's quite hard to say all the different cases at once, but it's got everything in there in examples, so please just go take a look at it. The next element of the duty of care we're going to look at is public authorities and whether they owe a duty of care to people. So in general, public authorities often don't owe a duty of care. That's because of the ANS 2 thing that we were talking about before, which is that it's not fair from a policy point of view for them to owe a duty of care for negligence. So let's say someone in the police force, if they were criminal, yes, let's hold them accountable, definitely if they're acting maliciously or criminally. But when someone in the police force acts negligently, that means they accidentally didn't do something or didn't live up to the standard that we think they should have. If we then say yes, someone can hold them accountable for that, really the society is going to be paying for that out of our taxes. So it's not really fair from a policy point of view to hold public authorities liable for negligence for everything. However, there are exceptions to this rule, as always. One exception is if there is a special relationship of proximity between the public authority and the person who got damaged by that public authority's negligence. So one case is the Dorset yacht case. It's quite famous, and it's about an island where these juvenile kind of boys were staying and the guards were negligent. They didn't watch the boys properly. The boys escaped at night and caused damage to the yachts down below on the island. So it's held that the guards, by acting negligently, did owe a duty of care to the people who own the yachts, and that's because there was a special relationship of proximity, according to this case, between these guards and those yacht owners, where it was extremely foreseeable that if they just let the boys do whatever they wanted, damage was likely to ensue to these yachts that were nearby. So therefore there was a special relationship of proximity between these two parties. However, in a different case, Hill and Chief Constable, where a young woman was murdered and the police, it was found they could have done more to stop this criminal and this murderer who was going around, but they made a few mistakes. It was held that the police force did not owe a duty of care to this young woman's mother or to this young woman's estate. Because this young woman was just a normal young woman and there was nothing special about her and her relationship with the police to make the police owe a duty of care to her. So there was no special relationship of proximity which overrode this criteria and made the police force owe a duty of care to her. However, in Swinney and Chief Constable, someone was a police informant and they came forward with information and the police negligently stored their information, so they got found out. And it was held that the police did have a special relationship of proximity with this person because that person came forward and the police should have held the information more responsibly. So yes, there was a duty of care in this situation. The next thing we're going to look at is vicarious liability. So in common law, people are generally only responsible for the actions they do themselves. If I walk down the street and punch someone in the face, that's an act of battery, you're not going to be responsible because you have nothing to do with me necessarily. However, vicarious liability is an exception to that rule, and it says that if you're in a relationship with someone where you have control over them, typically think employer-employee, and they do something in the scope of their employment or while they were under your control that creates damage, you can be liable for them even though you did nothing wrong. And that's simply because you have created the situation where they can act in this way, or you have control over them in some way. And it's also a policy reason, because let's say you're a company and your employees act negligently and someone sues the employees. They might not have any money, but you as a company might have money. So vicarious liability exists for policy reasons, and it's also a matter of fairness. For example, in the various claimants case, there were Catholic priest kind of teacher people who abused children, sadly, and it was held that the organisation who were responsible for these priests were vicariously liable for the priests. And that's because they had created this situation where the priests could go in and do the damage. The priests would never have had access to these children if not for the situation created by the organisation. So it's fair from this perspective to hold the organisation accountable for those priest actions. The first test is whether the nature of the relationship gives rise to vicarious liability. So things like the employee and the employer relationship do give rise to vicarious liability. Other relationships can. So in that various claimants case we just talked about, it was held that this relationship was akin to employment in that this organisation did have control over these priests, and therefore it satisfied this first element. In Arms and Nottingham Yorkshire Council, it was held that there were a few different things that could make it that could indicate whether something is akin to a relationship of employment. So I'm just going to read these out, and these things are whether the wrong was committed in an activity taken on behalf of the defendants, whether the wrongdoer's activities formed an integral part of the defendant's activities, whether the defendant increased the risk by wrongfully putting that person in that situation, whether the wrongdoer was under the control of the defendant, whether the defendant is more likely able to compensate the victim. So that's again what we're talking about with the company having deeper pockets. The second element is whether there is a sufficient connection between what the person was doing when they were doing something negligently and the person's role. So what that means is, let's say I'm hired to be a taxi driver, and on my break or on my weekend off I punch someone in the face. So my company might not be liable for me doing that because I wasn't doing anything in the role of my employment. Whereas if I were a taxi driver and I was driving extremely negligently while I had customers in the back, that is me doing something in my capacity as a taxi driver. So my company is more likely to be held liable for that. And that does make sense when you think about it, because again, it's back to that company has created the situation where I can act as a taxi driver. I probably wouldn't be able to get people in the back of my car that I don't know very easily without my taxi company. So they've created that situation of danger, the company has. So that's why you need to be in a situation where you're doing something in the course of your role in order to give rise to vicarious liability. An example of when this test was satisfied is the Muhammad and W.M. Morrison supermarkets case. So in this case, someone came in and abused a worker working at a supermarket. That worker came out and beat up that guy, and it was held that the supermarket chain was vicariously liable for the actions of their employee, and that's because the employee was basically acting in the scope of his employment, or there was a sufficient connection to his role and that action. So there was nothing to break the chain of causation from him working to him doing the abuse. It's not like he was out at a party on the weekend with nothing to do with the shop. It's that he was there, someone abused him at that shop, and he went out straight away in his uniform and beat that person up. So although he's not employed to beat people up, so it's not like he's acting in his role to do this, but there was a sufficient connection between his actions and his role that gives rise to the second test. The next heading is negligent misstatement, and whether someone owes a duty of care for words. So words are a lot easier to say than actions. People can say words far and wide, like I'm saying this on YouTube right now. So the question is, does someone owe a duty of care for words that they speak? And the answer to this is yes and no. But basically, in order to owe a duty of care to someone else for words that you say, you have to have a sufficient relationship of proximity. You have to have assumed responsibility for the person who you're saying the words to. So I haven't assumed any responsibility for people watching this video, and that means that I wouldn't be liable if people acted on my words. However, if I were an accountant, or when I am a lawyer and someone hires me to give them advice and my words are negligent, then they can sue me under negligent misstatement, because I assumed responsibility for them. I held myself out there as a professional, gave them expert advice, and I was negligent in doing that. So I can owe a duty of care to them. You would also need to show that the person who I gave my advice to relied on it for the proper purpose. In the Attorney General and Carter 2003, someone relied on information given to them for the wrong purpose. So it was a boat inspection, and someone relied on that inspection from the government to create a financial statement of how much their boat was worth. But really the inspection was to make sure it was seaworthy and safe. So this person, Carter, was not allowed to rely on this information for that purpose, and therefore there was no duty of care from the Attorney General or the government to Carter. The third thing you need to think about is whether the other person actually did act on the information and rely on your information. So if I'm a lawyer and I gave you advice and you acted on it, and I was the only person you sought advice from, and I was the sole purpose for the reason you acted and for the reason you lost whatever, then I could be held responsible. But if you sought legal advice from 15 people and you had a cousin who convinced you to do something, and there were all these different reasons why you made your decision, and you couldn't prove that my negligent advice caused you to do the thing and that you relied on it, then you wouldn't be able to prove that I owe you a duty of care under negligent misstatement. One last tip: if there is a disclaimer saying I take no responsibility for my words and any liability is on you, then it's not reasonable to rely on this information and hold the other person accountable, and the negligent misstatement duty of care will fail. The last thing we're going to look at in the duty of care heading is economic loss. So generally someone is only responsible for the type of damage they cause if it's consequent on physical damage or something like that. So basically that means you're not responsible for damage you cause if it's pure economic loss in general. However, in New Zealand, Taupo and Swinney, there was a case where some dams were negligently built by the council, and this caused damage to the property of a hotel owner, and this hotel owner lost people coming into this hotel for a period of time. And it was held that the council was responsible for this damage and for this loss of economic income. So the way the courts in New Zealand justified it was they said it kind of was consequent on the damage caused by the water to the hotel, but in reality it was more the reputation of people thinking it might be shut down, so they didn't come back again and again and again. So that means that it kind of was holding someone accountable for pure economic loss, which means just the money that they lost by not being open. So that meant that a duty of care was owed from the council to the hotel for their economic loss, although it was said that it was economic loss caused by the damage of the water, because people weren't coming back ultimately because the water damaged the hotel in the first place. That was an overview of a few things to think about with the duty of care element in negligence. Please like this video if you enjoyed it, and subscribe to my channel if you want to see more. You'll also like my series on the other elements of negligence if you liked this video, so please check those out. Thank you for watching, and see you next time. Bye!